The order determining heirs in a separate proceeding. Hi, I'm Darren Findling of the Probate Pro, and we're going to examine SCAO Form PC 554. SCAO for State Court Administrative Office, PC for Probate Court. This order is used following the hearing on a petition for determination of heirs in a deceased probate estate in which there isn't already a petition for probate that's been used. So it's a very niche used order, and it follows the petition for determination of heirs. With all of the SCAO forms, they are created by various statutes and court rules, and here MCL 700.3106 and MCR 5.308. This particular statute says that the court has exclusive jurisdiction over these matters in terms of determining heirs following the death, and that a petitioner can seek an order determining heirs without the necessity of going through the full probate administration. In fact, you can't use this particular process if a petition for probate has been filed, because in a petition for probate, you're asking the court to make a determination of testacy, whether there was a will, or intestacy, no will, as well as a requirement that with those petitions, there be a determination of the heirs. So the word heirs is a particularly defined term in Michigan's Estates and Protected Individual Code, as well as the court rule. It relates to the relationship level to the person that died. So we call them intestate heirs or heirs at law. So in this particular case, the court will have entered an order following hearing on a petition. And with all petition and motion practice, there's a petition filed, it is scheduled for hearing, it is served upon the interested parties, and notice is provided of that hearing, and then there's an adjudication, and this would be the court's order, the adjudication following the petition. Let's work our way through the order itself. Top left corner is the county, top right corner is the file number. And as you can see from the red rectangle, this is the order determining heirs in a separate proceeding. Now you can imagine its particular use. Imagine if you are a child of a decedent, but you're not named on the birth certificate, or the father's not named on the birth certificate, and there has never been a paternity order, and you want a determination that you're the child of the decedent. You may need it for Social Security purposes or to qualify for certain benefits, but you don't have any other assets. There are no other needs or reasons to go through a full probate administration. You could use this process. The estate name, date of hearing, and the judge's name, pretty simple. And here are the findings of the court. The court finds that notice of hearing was given to or waived by all the interested persons. We've discussed that a moment ago. The date of the decedent's death, and that they died intestate, and they were a resident of a particular location. It has to be the county upon which this probate is proceeding. 4, the property owned by the decedent at the date of death had a value, and this is just an approximate valuation. And this is designed really to see if there is a need for full probate administration. 5, there's been no proceedings for the administration. So this is the provision I mentioned earlier, that the full petition for probate has not occurred. So here is a finding of the court that no personal representative has been appointed and there has been no formal probate proceedings that have begun. And at the time of the date of death of the decedent, the following named persons were the heirs. So here are the identification of the heirs, and heirs are determined based on statute. So there are statutes that define whether somebody is an heir or not based on their level of relationship. The next section is the order section that kind of mirrors that which occurred in the findings above. The persons named are heirs of the decedent, and if there's any inheritance tax due. This is really a, there aren't many files that have inheritance taxes due anymore, but this is the place for it. The judge's signature, remember the judge speaks through its court orders. Now, with all of these processes, we strongly urge you to work with a skilled, competent probate lawyer to guide you through this process to make sure that you understand the appropriate process, the language, and how to navigate through this complicated process. At the Probate Pro, we are passionate about everything probate. If you have questions about a probate or trust matter or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.